Hi, good morning. My name is Seth German, and I'm one of the co-chairs for the Indian Law Committee for the South Dakota State Bar. We certainly appreciate everybody being here today and participating in this Law for Lunch. I am going to give a brief introduction of what we're going to do today and then introduce the speaker and we'll get going. So today our presentation was going to be presented by Tim Billion. He is an associate at, excuse me, at Robbins Kaplan LLP and works out of their Sioux Falls office. Tim practices primarily in Robin Kaplan's business litigation group and has represented clients in a variety of disputes. Tim attended law school at the University of Minnesota School of Law, where he graduated magna cum laude and was inducted into the Order of the Coif. During law school, Tim also served as a managing editor for the Minnesota Law Review. Prior to joining Robbins Kaplan, Tim clerked as a federal district court judge in Sioux Falls, South Dakota, and practiced general litigation for 2 years with a large law firm in Minneapolis. Tim is also a member of the Indian Law Committee, and we are incredibly pleased to have him presenting today. Just as an aside, you'll have an opportunity to submit text questions to today's presenter by typing your questions into the question pane of the control panel. You may send in your questions at any time during the presentation, and we will collect these and address them during the question and answer session at the end of today's presentation. So with that, Tim, please go ahead and start.
Great. Well, thank you for that introduction, Seth. Before I get started, I do want to thank Seth and the Indian Law Committee and the CLE Committee and the State Bar for this opportunity to present, and of course the Bar staff for their help with setting up the logistics of this presentation. And of course, thank you to all of those who are listening today. As Seth covered in my background, I practice in a variety of litigation areas. The bulk of my work right now consists of trust and fiduciary litigation, internal investigation, tribal work, which is the topic of today's presentation, plaintiff's personal injury litigation, and appellate work. And as Seth mentioned, I'm a member of the State Bar's Indian Law Committee. Our firm, Robbins Kaplan, has 8 offices across the country with a total of about 250 attorneys. We have 3 attorneys here in our Sioux Falls office, including myself. The other 2 are Brendan Johnson and Erica Ramsey, and I'm very fortunate to get to practice with the 2 of them every day. Today's topic is tribal sovereign immunity and its application to tribal entities, otherwise called arms of the tribe. To set the stage a little bit, there are 573 federally recognized Indian nations in the United States, variously called tribes, nations, bands, pueblos, rancherias, a variety of other terms. But by using the term tribes in this presentation, I mean groups that are formally recognized by the Bureau of Indian Affairs. Here in South Dakota, as many of you probably know, we have 9 recognized tribes. Of those 9, the Standing Rock Sioux is headquartered in North Dakota, but does have tribal land in both North and South Dakota. Many tribes across the country generate revenue through tribally owned businesses. These tribally owned businesses can share the tribe's sovereign immunity if they are sufficiently linked to the tribe itself to be considered an arm of the tribe. In determining whether a tribal entity is an arm of the tribe, courts in states and federal circuits around the country have applied a variety of different arm of the tribe tests. This presentation is going to look at some of the key decisions and explore some particularly recent developments in how courts evaluate whether a tribally owned business is an arm of the tribe. So, as a starting point, tribal governments are sovereigns, independent from both states and the federal government. In fact, Article 1, Section 8 of the United States Constitution states that Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So this separate sovereignty goes all the way back to the Constitution and before. One of the privileges extended to sovereigns at common law was immunity from suit. And without really diving into that issue here, the federal government and state governments also enjoy sovereign immunity, although in many instances, they have waived that immunity by statute. There is a long line of cases, a few of which you can see on the screen here, that recognize that tribes also enjoy sovereign immunity. Because tribes are in a unique position relative to the federal government, tribal sovereign immunity can be limited or abrogated by Congress, but not by states, only by an act of Congress. Notably, the United States Supreme Court has held that absent congressional limitation, tribal sovereign immunity applies without a distinction between on or off reservation activity or between governmental and commercial conduct. And the Kiowa Tribe of Oklahoma decision you see on the screen is one of the key holdings for that point. So the extension of sovereign immunity to commercial off-reservation conduct by tribes is sort of the necessary condition in some respects for the arm of the tribe issue. As we see in this slide, Congress and the courts recognize that it's important for tribal governments to raise money to fund their sovereign functions. One challenge facing tribes, though, is how to generate those government funds. State governments typically raise funds for their operations by imposing taxes. We're all familiar with those. Tribal governments, however, often lack that ability from a practical perspective. Tribal governments can encounter a number of factors that limit their ability to generate revenue in traditional ways, such as territorial remoteness, public infrastructure challenges, a lack of access to capital, and lack of traditional tax base, particularly when much of the land that composes reservations is held in trust by the federal government. And of course, we all know that many tribes and reservation communities, including some in our own state, face a number of social challenges as well. And tribes often suffer from the difficult and fraught historical relationship between tribes in the United States. The point of this presentation is not to explore the challenges facing tribes, but I mention these issues insofar as they are relevant to understanding why tribes have devised different strategies for economic development. Many tribes, to do so, have turned to tribally owned businesses. In fact, you see the citation for the Bay Mills decision there. In Justice Sotomayor's concurring opinion in Bay Mills, she noted that, quote, if tribes are ever to become more self-sufficient and fund a more substantial portion of their own governmental functions, commercial enterprises will likely be a central means of achieving that goal, close quote. And the goals of economic self-sufficiency and self-determination are, I think, a pretty well-established goal of the federal government and, of course, of tribes themselves. Let's look at some examples of how tribes have utilized tribally owned businesses to generate revenue and provide government services. The most familiar example to most of us is the tribal casino. Many tribes have taken advantage of their relative freedom from state gaming regulations to open casinos. The gaming revenue generated by these operations can be used then to fund various governmental services. I will note before we move on that tribal gaming is subject to federal control under IGRA, which, among other things, imposes a cap on how much money can go to non-tribal management entities, for example. Some tribes have also entered into gaming compacts with their states that also can control their operations. Regardless, the growth and familiarity of the tribal gaming industry underscores, I think, at a fundamental level, the potential for tribally owned businesses to act as engines of tribal economic development. Not all tribes are positioned financially or geographically to operate a casino. So other tribes have utilized tribal entities to provide more traditional government functions such as education or housing for tribal members, One emerging area of economic development is the provision of online financial services. So these are just a few examples of, situations in which a tribe as a sovereign entity may own an entity that is engaging in a commercial activity. So given the variety of forms that tribal businesses can take, how do courts determine if a tribally owned commercial entity is a sovereign arm of the tribe or if it's simply another commercial business? I put the question that I think is at the heart of the matter on the screen here. At a high level, courts try to determine if a business entity, they ask, quote, whether the entity acts as an arm of the tribe so that its activities are properly deemed to be those of the tribe. And you'll note one of the citations there is from an Eighth Circuit case, which is particularly relevant in our jurisdiction. I want to talk about a few notable cases in this area. Courts have come up with a variety of different multi-factor tests to try to figure out when an entity is an arm of the tribe. These approaches are not consistent, and the law can vary significantly from one jurisdiction to another. There's also an interesting evolution of law as courts become more accepting of tribal gaming over time. And a similar evolution is going on right now as courts react to the development of tribal online financial services. Some of those businesses legitimate and some of them not, as we'll touch on later. I'm not going to track down every decision or note every outlier. We would quickly run out of time. Instead, I'm going to try to use a few of these cases to help illustrate the general arm of the tribe concept, and then we'll get into some more modern developments. So the first case noted here on the screen, the Minnesota Supreme Court undertook one of the first efforts to create a detailed set of elements of the arm of the tribe test in the Little Six decision. It's a 1996 decision. You'll see the citation on your screen. Certainly not the first decision to deal with the arm of the tribe test, but most of the prior opinions were fairly limited in their analysis. And this was one of the first efforts, along with the New York State Court, to really set forth a factor-driven test. Little Six was a tribal business incorporated under tribal law that operated a casino on the reservation. Little Six issued a single share of stock owned by all the voting members of the tribe. A plaintiff sued Little Six for various torts based on her former employment as a security guard at the casino. The Minnesota Supreme Court articulated the factors to be considered in determining whether to extend tribal sovereign immunity to the casino. They were, quote, one, whether the business entity is organized for a purpose that is governmental in nature rather than commercial. Two, whether the tribe and the business entity are closely linked in governing structure and other characteristics. And three, whether federal policies intended to promote Indian tribal autonomy are furthered by the extension of immunity to the business entity. That's at page 294 of the opinion. The court ultimately determined that Little Six did share the tribe's immunity, and it was based on the following facts. Little Six was created for the specific purpose of improving the financial or general welfare of the tribe. That was based on its articles of incorporation, which also expressly extended sovereign immunity to Little Six. Little Six was wholly owned by the tribe as a governmental unit. It wasn't owned by private citizens. And Little Six's board of directors was required to include at least 3 members of the tribe's business council, and a majority of the board was required to be tribal members. Directors of the company could be removed in a tribal court proceeding commenced by 10% of the voting members of the tribe. So based on those facts, the court found that there was a sufficiently close link between the tribe and the management of the entity. The Minnesota Supreme Court also found that federal law supported the notion that gaming is closely linked to the well-being of tribes, and the court rejected the fact that the casino was for profit as a relevant consideration, arguing that Sovereignty is not limited to only government activity like housing or education. Gaming here was intended to further the tribe's economic development and self-determination with our government functions. The court also rejected the argument that the tribe needed to control the day-to-day operations of the casino. It said, quote, "Control of a corporation need not mean control of business minutiae. The tribe can be enmeshed in the direction and control of the business without being involved in the actual management," close quote. I want to go through some of those facts because now I'd like to contrast that case with a different case where the commercial entity ultimately did not share the tribe's sovereign immunity. That's the Seaport Loan Products case. That's the second citation on the screen in front of you. The Lower Brule Community Development Enterprises was sued and moved to dismiss the lawsuit based on sovereign immunity. There were some facts that weighed in favor of immunity here, like Little Six. Lower Brule's 8-member board was comprised of 6 tribal officials. The tribal council had the power to dismiss board members, and the bank accounts of the entity were controlled by the tribal council in that checks and withdrawals needed to be approved and signed by 2 members of the board, one of whom had to also be a member of the tribal council. Nonetheless, though, there were a number of facts that weighed against immunity. For example, Lower Brule was organized under Delaware law. It was not organized under tribal law. Its primary activity was investing in New York financial services industries. One of the entity's purposes in its articles of incorporation, or articles of organization rather, was to make loans, microloans to individual tribal members, but testimony showed that in fact no such loans had been made and the microloan program had never actually been set up. There was no space on the reservation, no full-time employees, no website. Although the articles of organization and the operating agreement had boilerplate language about providing economic benefits to the tribe, there was no evidence that the entity had ever sent any money back to the tribe. And although it was required to provide a bunch of financial reporting, it hadn't done so in years. So ultimately, the court on those facts concluded that the Lower Brule community development enterprise was more of a for-profit entity that wasn't entitled to immunity. I wanted to go through those 2 cases in some level of detail because I think that contrast is what's at the heart of the arm of the tribe question. Is the entity sufficiently linked to the tribal government, or is it more like a for-profit entity with only an incidental, indirect, or passive relationship to a tribe? I do want to talk a little bit about the Hagen decision because we're in the 8th Circuit. In that case, 2 plaintiffs sued a community college alleging discrimination. The college was chartered by the tribe as a nonprofit corporation. The board was comprised of 1 enrolled member from each of the tribe's 7 districts, and it was undisputed that the college was chartered, funded, and controlled by the tribe. There wasn't a lot of factual development in that case, but it does establish here in the 8th Circuit the proposition that tribal entities are entitled to immunity as arms of the tribe. At the circuit level, the 8th Circuit has not adopted an express set of elements or tests for determining whether a tribal entity qualifies as an arm of the tribe, but Judge Lang here in the District of South Dakota dealt with the issue fairly recently in 2012 in the J.L. Ward decision. J.L. Ward sued the Great Plains Tribal Chairman's Health Board for a variety of contract and fraud claims based on the board's use of allegedly copyrighted material. The district court ultimately found that the board was entitled to immunity. Some of the facts that weighed against immunity were the fact that the board was incorporated under South Dakota law, not under tribal law, and a suit against the board would not affect any particular tribe's fiscal resources. There were 16 member tribes, and no one of them would have been responsible for a judgment against the board. Nevertheless, though, there were plenty of facts that did support immunity in that case. The 16 tribes formed the board to negotiate with the IHS Great Plains Agency and other federal agencies on behalf of the tribes on healthcare matters. The Articles of Incorporation included a number of purposes along the lines of providing health services to tribal members. No private individual received any financial benefit from the entity, except that employees were compensated in the ordinary course of business. The board was governed by the elected chairs of its 16-member tribes. And so ultimately, the court found that the purpose of sovereign immunity was furthered by extending it to the board, because the board promoted the preservation of tribal autonomy, self-determination by representing the interests of the member tribes to the federal government and related federal agencies. In that decision, Judge Lang found persuasive the next case we're going to talk about, the breakthrough management decision. Breakthrough management was really a landmark decision out of the 10th Circuit. In that case, a company sued a tribal casino for allegedly misusing some training materials. The district court found that the casino did not share the tribe's immunity. The 10th Circuit reversed. It assembled a list of factors that it said were, quote, helpful in determining whether an entity qualifies as an arm of the tribe. You can see them on your screen. They're not exclusive or exhaustive factors, but they are: 1, the method of creation of the economic entities; 2, their purpose; 3, their structure, ownership, and management, including the amount of control the tribe has over the entities; 4, the tribe's intent with respect to the sharing of its sovereign immunity; and 5, the financial relationship between the tribes and the entities. The court also considered a 6th factor, the overall purpose, and whether that purpose was furthered by extending immunity to the entity. The court in the breakthrough management decision looked at the following facts. The casino and there was a tribal economic development authority that actually owned and operated the casino. And both those entities were created under tribal law as subordinate entities of the tribe. The resolution that created the authority stated that the purpose was to further the best interests of the tribe. 50% of the revenue from the casino went to tribal government functions, including programs like education, healthcare, cultural preservation, childcare, the judicial system, and law enforcement. 15% of the revenue went to tribal economic development, 10% went to a tribal trust fund, and 25% was distributed among tribal members on a per capita basis. The board of directors for the authority was the same as the sitting members of the tribal council. Although the casino had a 15-member board and most of them were not tribal members, the casino was controlled by the authority there. And because the tribe depended so heavily on the casino to fund its government, a reduction in the casino's revenue would effectively really reduce the tribe's income and budget as well. So ultimately, the court in breakthrough found that the casino and the authority were entitled to share the tribe's immunity there. And this test has been cited approvingly by a relatively large number of courts since it was handed down, as I mentioned, including Judge Lang in the jail ward decision here in South Dakota. So up until that point, case law had been relatively consistent and relatively uniform in looking mostly at the formalities of how entities were formed, created, organized, and really managed at a high level. In late 2016, the California Supreme Court issued the Miami Nation decision, which represented an important shift in how closely courts scrutinized tribal entities. In Miami Nation, the court adopted a modified version of the 10th Circuit's breakthrough test. It adopted the first 5 factors, but it found that the 6th factor was really repetitive of the other 5 factors, and so it just said consider the 6th factor as you are considering the other 5 factors. It's not really a separate issue in the test. But in so doing, the court emphasized that the breakthrough test should be applied to, quote, how such arrangements function as a practical matter. We'll look at how they did that, because that's what's really important here. The Miami Nation case involved 2 tribal lending operations. Both were incorporated under tribal law. Although the entities were formed under tribal law, the court noted that this factor was not all that persuasive because the initial capital came from outside the companies, and 4 of the 5 trademarks owned were previously registered to a non-tribal entity. Although the express purpose for the entities was to benefit the tribe, the court found that there was not a close enough match between that purpose and the reality of how the businesses were controlled and operated financially. And that was sort of the key analytical step that the Miami Nation decision added. For a variety of reasons, the court found that the tribe was essentially a passive owner of the businesses and received minimal financial benefit. And there was no evidence regarding how the minimal amount of money that did find its way back to the tribe was used to provide governmental services. This decision may well have been a reaction to particularly bad facts. The 2 lending enterprises in this case were associated a little downstream from a gentleman named Scott Tucker. That name might be familiar. He is currently in federal prison for running what has been referred to as a rent-a-tribe lending scheme. So needless to say, not great facts there for the two lending entities. Ultimately, the court concluded that only the tribal intent factor weighed in favor of immunity, and the other factors either were not persuasive or weighed against immunity, and so they were not entitled to it. But again, the key development out of this case was the emphasis on how the businesses functioned as a practical matter. This resulted in a much more in-depth and subjective inquiry than the more formal questions that have been previously asked by courts. So rather than looking at the formation documents, tribal resolutions or articles of incorporation or organization to determine the purpose of the entity, the court dove much deeper into the mechanics of the business, how employees were compensated, how day-to-day decisions were made, how property came into the entity. So it was a much more searching inquiry than had been undertaken by other courts. A line of cases in the Fourth Circuit illustrates the impact of this shift in the application of the arm of the tribe test following the Miami Nation decision. What I think is particularly interesting here is that all of these cases arise in the tribal lending context, and they're all in the same circuit. So I think they're really ripe for comparison. I'll move rather quickly through the earlier cases. Everett v. Mitchum was a 2015 decision from the District Court in Maryland, 146 F sub 3rd 720. In that case, 2 tribal lending entities, Mobile Loans and Riverbend, moved to dismiss a putative class action brought against them by a consumer who took out loans from those entities. The plaintiff, in turn, sought to take jurisdictional discovery. The court denied the plaintiff's motion and dismissed because, quote, there is no evidence that the tribes do not own and control Mobile Loans and Riverbend, and permitting jurisdictional discovery would undermine the purposes of the sovereign immunity doctrine, close quote. In that case, the court applied the breakthrough test to determine that the lenders were arms of the tribes, and all the facts were established, as in a lot of earlier decisions, using the entity's charters, their operating agreements, and a few declarations from officers. It was a pretty formal and compact inquiry. In Howard v. Plain Green, which was a 2017 decision from the Eastern District of Virginia, a consumer sued Plain Green for alleged violations of the Fair Credit Reporting Act. The court found that Plain Green was an arm of the tribe. In so doing, it applied the breakthrough test, and again, largely confined itself to examination of the relevant formation documents, and concluded that the entity was an arm of the tribe. So again, those two decisions were largely consistent with the formalistic approach taken in most courts up to that point in time. Then in the Williams v. Big Picture Loans decision, which the citation again is up on your screen, it's a 2018 decision from the Eastern District of Virginia. The court reached the opposite conclusion. The most interesting part of this decision for our purposes today is the way the district court applied the breakthrough test. Rather than Everett and Howard, which applied the breakthrough test in the fairly limited and formal way that had been done in the past, Williams v. Big Picture, the district court really dove in deeply and followed the Miami Nation approach. There were two entities involved. Their names were Big Picture and Ascension, and they were both involved in tribal lending. The court considered the functional relationship between those entities in the tribe rather than the formal structures. In particular, regarding the first factor, the court acknowledged that the entities were organized under tribal law and operated pursuant to tribal ordinance, but the court found it very important that the tribal entities didn't start their own business. They absorbed the operations of a previously existing non-tribal lending enterprise. So the court found that factor of limited value. Regarding the purpose of the entities, the court found that the stated purpose of the entities was to promote the tribe's economic self-sufficiency, but then essentially the court rejected that stated purpose because it felt that the entity's economic performance didn't actually provide those benefits to the tribe. Although Big Picture contributed 10% of the tribe's general fund, the court noted it didn't have any information on how those funds were used by the tribe to support government services or the portion of the entity's revenue that actually went to the tribe. Essentially, the court found that the primary purpose of the formation of the entities was really to help non-tribal individuals and entities make money and avoid liability. So the court found the purpose factor did not weigh in favor of immunity. Regarding the structure, control, and management factor of the tribal entities, it was largely undisputed that Big Picture was tribally controlled. It was directly owned by the tribe. It was managed by two tribal members who were appointed by the tribal council. They were subject to removal by the council. Many of the employees were tribal members working on the reservation. But the court found that the control over Big Picture was rendered meaningless by the functional reality that Ascension, the other entity, actually dominated the lending operation, and Ascension wasn't sufficiently controlled by the tribe in the court's opinion. The tribal managers were not familiar with the operations of Ascension. They exercised little to no supervisory or co-managerial authority over the day-to-day operations. They approved some things like operating budgets, but they generally were removed from the day-to-day operations of the business. And most of those functions were delegated to a non-tribal CEO. And as I mentioned before, there was very little evidence regarding the financial benefit that the entities conferred on the tribe. So based on all of that, the district court found that the entities were not entitled to immunity. As you can see in the second bullet point here, the Fourth Circuit on July 3rd of 2019 reversed with instructions to dismiss the complaint based on the entity's sovereign immunity. The Fourth Circuit expressly adopted the first 5 breakthrough factors. But interestingly, the Fourth Circuit found no error in the district court's factual findings. Instead, it reversed the legal conclusions based on those facts as found by the district court. In particular, the Fourth Circuit rejected the district court's rationale for disregarding the stated purpose of the entities. As you recall, the district court's reasoning was the primary purpose was actually to help people and entities other than the tribe, and the Fourth Circuit said you can't disregard what the formation documents say. Similarly, the Fourth Circuit rejected the district court's conclusions about the financial relationship being too vague. about compensation to non-tribal employees being outsized as compared to other employees. And finally, regarding the control factor, the Fourth Circuit reaffirmed the idea that a tribe can outsource the day-to-day management of a business without ceding control or giving up its immunity. So all in all, the Fourth Circuit's decision walked back the district court's reliance on particular facts to outweigh or counter the formal factors regarding purpose, intent, and control. Thus, I read this decision as swinging the pendulum back a little bit from the extremely fact-intensive focus employed by the district court and back towards an approach that's a little more balanced between the factual and the formal. But as we can see from this seesawing in the Fourth Circuit, courts are struggling with how to apply the arm of the tribe principles, and particularly how to apply them to online businesses. And tribal entities are struggling with how to ensure compliance with the arm of the tribe test in jurisdictions across the country while still operating a business efficiently and professionally. This line of cases in particular, involving the same industry in the same circuit over a span of just a few years, I think is a really good illustration of how much uncertainty there is in this area of the law currently. So, synthesizing at a very general level, what does an arm of the tribe look like? First, the formalities need to be in place. That means the relevant tribal resolutions and articles of incorporation need to be clear that the tribe intends to operate the business as an arm of its government and share its immunity, and that the business is intended to promote the economic development and tribal self-determination. Second, I think the relationship between the tribe and the entity needs to bear some relationship to the formal purpose. This breaks down into two buckets: control of the entity and financials. The tribe needs to maintain oversight and formal control over the entity, particularly at the board of director level. The relationship between the tribe and the business is going to be different for every business and for every tribe. So there's no one size fits all solution. But, and in particular, some tribes may have the expertise to manage the day-to-day affairs of a particular business. That's great. But other tribes may need to hire outside managers, at least to get a business started. That arrangement can work too, so long as the tribe retains oversight and decision-making control on the major issues. In terms of the financial relationship between the entity and the tribe does need to derive a significant financial benefit from the business profits. Others certainly, such as employees, managers, business partners can benefit as well. But again, the financial relationship is going to depend on a lot of factors for each business, and also vary depending on how established the business is. But ultimately, the more a tribe can tie the money earned from the business to the provision of its government services and the fulfillment of its sovereign functions, the stronger the arm of the tribe position is. I want to finish up just by briefly discussing why this matters. Obviously, if you represent a tribe or a tribally owned business, it's important to preserve the parties or the entity's immunity if you can and if you want to. If you represent a party who's considering entering into a contract with a tribally owned business, be aware that business may be immune from suit, and consider whether the contract should include a limited but express waiver of immunity. If you represent a plaintiff considering a claim against a tribally owned business, immunity may present a significant hurdle, just as it would if you were bringing a claim against the state. So those are all issues to think through that may arise in anyone's individual practice. From a bigger picture perspective, though, we have 9 tribes with a presence in our state. The internet makes it easier to do business across the country at the press of a button. And simultaneously, the internet can really blur jurisdictional lines. It's clear where a casino is located, for example, but it's less clear where an online transaction may take place. Issues regarding tribal businesses and immunity, I think, are likely to become more frequent as more tribes use the internet as a means of creating commerce to sustain their tribes. And I think the arm of the tribe issue is an important one to know as more tribes engage in commerce through tribally owned entities. So with that, I think I've gone on for almost 40 minutes. I will stop there and throw it back to Seth to see if there are any questions.
Thank you, Tim. That was fantastic. Again, if anybody has any questions, if you could include that in the question toolbar within the controls there, those would be greatly appreciated. I haven't caught any yet, Beth, unless I haven't received those yet. But I had a question for you, Tim, while we wait for others. In the event that a tribal organization that's partnered with some other entity is in existence now and maybe doesn't meet some of those clear factors, what advice would you give to that tribe so that they could strengthen their legal position?
Well, the nice thing is that, tribes are always in control of a lot of those formalistic factors. You can always pass a new tribal resolution if, for example, a tribal resolution that originally formed a business didn't expressly say, we intend to share the tribe's immunity with this entity. You can pass another resolution. In some circumstances, I am aware of situations where tribes, in an effort to reorganize and restructure businesses, have essentially created new entities and done mergers. It's going to depend a lot on the specific facts there, and also on what may work for that particular business. But a lot of those formal factors are, relatively easy to resolve, because they all relate back to what's the tribe's intent, what's the tribe's purpose, and if the tribe just hasn't expressed that clearly, it can do so.
Thanks, Tim. As of right now, it doesn't look like we have any additional questions. If anybody wants to pose a question after the oh, 1 second. Okay, if anybody has, we still don't have any questions. If anybody has any additional questions, feel free to shoot them in an email to some of the organizers here, and we'll try to get those addressed for you. But again, I'd like to thank Tim for this incredible presentation. And with that, we appreciate all of the attendees at this Law for Lunch put together by the Indian Law Committee. I'd also like to thank the State Bar Office, specifically Nicole and Beth, who are incredible and continue to make all of our lives easier. Thanks again for everybody attending.